All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for argument in the City of Phoenix versus State of Arizona, our civil number 18-0109. Each side will have 20 minutes within which to make their arguments here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We have read the briefs, we've been through the record, we've conferenced the case, so we're familiar with the underlying facts and certainly the legal issues that have been raised in the briefs. So please keep that in mind as you make your arguments here this morning. We're recording these proceedings both by audio and video, so we would appreciate it if when you approach the podium to begin your argument, you identify yourself and your client for us. With that, appellant may proceed.
Thank you, Your Honors. My name is Joseph Roth for Osborne Maladon on behalf of the appellant, the City of Phoenix, and may it please the Court. Your Honors, this case is a very straightforward case of textual interpretation. The Court should reverse a Superior Court below because the City adopted a boundary map in Resolution 21370 in November of 2015 when that resolution designated the exterior boundary lines and referred to a map showing the exterior boundary lines pursuant to 48576A. That should end this case. The state's contrary interpretation requires the court to deny that, quote, a map showing the exterior boundary lines is a boundary map. To get around that conclusion, the Superior Court accepted the state's position below that extrinsic evidence indicates that boundary map must mean something else because, according to the state, the extrinsic evidence shows that the legislature intended for the law to apply to the Roosevelt Business Improvement District.
This is probably not relevant at all to the legal issues, but remind me as to why the city wanted to create a business district.
The Roosevelt Business Improvement District is a hotspot for cultural and arts development. The city is looking to encourage development in that area and wanted to create what is called an enhanced municipal services district to provide for beautification and attractions for tourists and the general benefit of that district. That's seen enormous growth over time. And
the objections that were received were from residents who didn't want to pay for those enhanced features?
I think that the objections range from the process as it played out to being subjected to the assessments required to pay for that, yes.
Okay, thank you.
Yes. The city, however, urges the court to reject application of HB 2440, which is what we're here about today, to that Roosevelt Business Improvement District because the text controls here. When the text is unambiguous, the court's inquiry stops there. And the extrinsic evidence that the state relies on and that the Superior Court relied on below should not create an ambiguity that does not otherwise exist. Here, an examination of HB 2440 is all the court needs to do. It's all the evidence the court needs to reach a conclusion as to the meaning of the text. The text that's at issue here is Section 3 of a 3-section bill. That section says that the law that's being amended there will be retroactive for any district for which a town or council, the governing body, has not adopted a boundary map by January 1st of 2016. The court looks, of course, the term boundary map is not separately defined, but what is defined is if the court were to read the other two sections, which are the only sections that the law amends, it will see the only requirement in the code requiring the city or town council or other governing body to pass a resolution that specifies the boundaries of an improvement district or establishes the extent of the district or designates the boundaries of the district or refers to a map that shows the exterior boundary lines of the district.
Talk about a boundary map. Is discussed? Or is that a fixed boundary that everyone can rely on from there on out as being the exterior boundaries of the proposed permanent district?
That's a good question, Your Honor. It quite clearly is a fixed boundary from that point forward. If at some point the governing body changes the boundary, the statutes provide in 48579E, I believe, that the process has to start over. The City Council has to go back, if they wish to proceed with a different boundaried district, has to pass a new resolution of intention under one of the provisions that this HB 2440 amends. So the process has to start over. The only time the boundaries are fixed, and they are fixed for the entire time the district exists, is with the adoption of the resolution of intention, is what it's called, or ordinance of intention.
Proposed boundary that you're talking about, that you're relying on, not an established or a fixed or a permanently recognized boundary.
No, I don't agree with that, Your Honor. It is a fixed boundary. If it ever changes, the entire process must begin again. Once the boundary is fixed, that gives property owners a right to file objections and be heard. The objections are seen as meritorious, and the City Council the statute says to modify the district, then the statute says a new resolution of intention must be adopted. That did not occur here. The only time the City Council adopts boundaries is with the resolution of intention pursuant to 48576, or in the case of a different kind of district, 48505, the two sections that HB 2440 amends. So looking just at the text of HB 2440, we submit is all that the court needs to do to understand the meaning of boundary map. No one reading that bill could come to a different conclusion as to what boundary map must refer to. It's the boundary setting requirements contained in the only sections that the bill amends. The well-established precedent says that the court looks to that text, looks to the context to understand the meaning of words in legislation. Here, that is the statutory context. The four corners of HB 2440 is all this court needs to rely on. But even looking outside of HB 2440 sections, looking to the statutory structure for districts as a whole, there is no other provision, no other place where the governing body is required or needs to establish the boundaries of a district. That is it. The state, however, refers to a different source for the word boundary map. They say it must mean the diagram, the assessment diagram. It appears in other statutes. It is not referenced, cross-referenced in HB 2440 or the sections that HB 2440 amends. More critically, though, the diagram does not establish a boundary. The state's interpretation requires muting that word out of the retroactivity clause in Section 3. The statutes say that a diagram provides details of property contained within a district. That is, a district that already exists, that already has fixed boundaries. In addition, a diagram is a requirement that comes into play at a different part of the process than is concerned in HB 2440. It is something that the city must do before assessments can be made on the property owners to pay for the work. But the city can have already procured contracts, ordered work be done, incurred liability basically. Only when it wishes to then make the assessment on the property owners within the fixed district must it make and approve this diagram, according to 48575, which is for the enhanced municipal districts that we're dealing with here. This textual interpretation that the state pushes really isn't a textual interpretation, because there's no relationship between boundary map and diagram other than that you might say that a diagram is a kind of map. But again, that requires ignoring the word boundary and ignoring the boundary setting requirements contained within HB 2440. More importantly, the state reduces the city's argument to an assertion that where the city's only referring to this map on file. That is not the city's position. The city's position is that a boundary map refers to the boundary setting requirements contained within HB 2440. More importantly, though, the court doesn't need to reach that issue, because unquestionably here, with the resolution passed in November of 2018, the city did adopt a boundary map. So the court need not reach to understand the outer boundaries and the hypotheticals involved with boundary map. It need only see that a boundary map and a map showing the exterior boundary lines are the same thing.
So what happened in November was the city passed the resolution of intention, correct?
That's correct.
And when did the city order the improvements?
The city has not ordered improvements. The city could order improvements and was authorized to do so once it rejected the protests and objections that property owners filed.
Right. So isn't that really the crux of the case? The fact that the improvements were never ordered really puts this case, or the BID, within HB 2440? Isn't that the problem for you?
I don't agree with that, Your Honor. I think that this court must only look at the text of Section 3. And the retroactivity is keyed not off of when the improvements may be ordered, not when they actually are ordered, but when the city adopts a boundary map. And the only time that could have occurred is when the resolution of intention was passed in November of 2015. The state's analysis really is about reaching a conclusion that the law must apply to the Roosevelt Business Improvement District, so therefore we need to find some location in the statute that could qualify as a boundary map. That turns statutory interpretation on its head. This is precisely what this court recently held in the Kleckner case, which we filed a notice of supplemental authority on, where there was some legislative history that could be read to indicate that the legislature wanted the Department of Health Services to expand the scope of midwifery, but the legislation actually did not require that. And the court said, we go no further than the text. The text is unambiguous, and the analysis stops there. We do not rely on the legislative history to cloud what is otherwise a clear reading of the text. Now, the state wants this court to get to extrinsic evidence because it wants to use that extrinsic evidence to create this ambiguity. But the use of extrinsic evidence here is improper for the reason I've said. The text is the best evidence. The text is what this court should look at. And there is no textual argument leading to the conclusion that the city's interpretation is unreasonable.
So the fact that the term boundary map is not described or defined does not in and of itself create any ambiguity?
No, the term it could only refer to essentially the same term being used in Section 2 of HB 2440. The requirement that there be a resolution passed that specifies the boundaries or establishes the extent of the district or refers to a map on file showing the exterior boundary lines. The parallel in text between those two could not be clearer. And any reader looking at that could only conclude that boundary map in Section 3 must mean map showing boundary in Section 2. They're essentially referencing each other in the text. The only way an ambiguity comes up is by reference to certain extrinsic evidence, where the state insists that it shows that everyone must have understood it to mean something else, even though the text doesn't say something else. Well, a legion of
states say that even the city recognized as meaning something else?
The state asserts that certain evidence indicates that the city referred to boundary map and diagram interchangeably at times, which in certain minutes and in agenda items, that is true. The city did that. But the city's own imprecise use of these terms does not shed light on the meaning of a later enacted bill and by a different legislative body than the city. And I would urge the court to look at the actual text of the resolution passed and adopted by the city, which does not confuse those terms and quite clearly establishes a map, establishes the boundaries of the Roosevelt District. Now, there's two problems with the court, the state's reliance and the court below's reliance on this extrinsic evidence. Those problems are, one, it's improper, as we've gone over. Number two, the evidence that is pointed to here is very low value. Among the lowest values, we have comments from 4 legislators of 90, and we have the city's imprecise use of these terms prior to the adoption of the legislation. Those are either of very low value as evidence or no value whatsoever, particularly in the case of non-legislators. That, again, is what this court said in Kleckner, where the proponent of a different interpretation there urged the court to look at non-legislators who had lobbied for this bill and urged that there's no way they would have lobbied for the outcome that was being held there. So even if the court were to get to this extrinsic evidence, it's simply not valuable here. There's no Senate fact sheet, no House fact sheet, things that typically the court would look to for evidence of legislative intent outside of the text, indicating anything about the meaning of boundary map that differs from the city's interpretation or supports the state's interpretation. So what we're left with is the state insisting, based on very low value evidence, that its interpretation must be correct because it says that evidence shows an intent to apply this law to the Roosevelt Business Improvement District, when the text of the actual bill does not say that, does not indicate that, and quite clearly says something different about the boundary map and the scope of the bill that's being amending the statute there. So what we're left with then is an overreach based on extrinsic evidence, based on a conclusion that this law was intended to target the Roosevelt Business Improvement District. That leads us to a separate problem with this bill. If that is correct, then this is a special law prohibited by the Constitution. And there, the issue is that the Roosevelt Business Improvement District is a member of an inelastic class. And we cited all the cases there and the test there, and there's no disagreement between the parties as to what the test is. The disagreement is that Roosevelt Business Improvement District is being treated differently than any other business improvement district in the past or in the future. It is the member of an inelastic class that's being targeted for repeal. If the law applies, if HB 2440 applies to the Roosevelt Business Improvement District, that means the repeal of the business district.
How does it not affect others in the future?
The difference there is that the retroactivity clause does not merely apply the law to Roosevelt Business Improvement District. The difference is that the Roosevelt District cannot comply with the law. It's not a mere application of these new requirements regarding petition signing and property owner opt-in. That would apply to any future district.
Can't they just start the process over? Can't the city just start the process over?
It could. That's true with respect to any repeal or any differently treated district. The fact is, any future district is not going to be subject to that same treatment.
Subject to the 120-day dilemma.
Yes, and the dilemma exists because that 120-day timeline started on January 20th, 2016, ran out on May 19th. This bill did not become law until August.
Do you agree that the content of the law itself can be imposed on any number of improvement districts hereafter? The requirements that it puts in place. It's just the retroactivity portion of it that you disagree with, right?
That's correct. The
The statute itself could be applied, and the other would just be inapplicable, right?
The statute could be applied to the Roosevelt Business Improvement District.
The statute could be applied to any business improvement district that failed to meet the requirements that are in the statute now. It's just the retroactivity that would be inapplicable to any improvement district from here on out.
That's correct. The retroactivity cannot apply to the Roosevelt Business Improvement District because it means repeal. It doesn't only mean application of the law to the Roosevelt District. Any future district, yes, would be subject to the requirements of HB 2440.
As written.
As written.
Thank you.
That's correct. I'm going to reserve the remainder of my time. Thank you.
Thank you.
May it please the Court. I am Rusty Crandall here on behalf of the State of Arizona. To prevail, the city has to show that there is no ambiguity. If there's any ambiguity, the state wins. This is so because nothing in the legislative or city council records supports the city's position. But the city cannot show that its interpretation is unambiguous. A textual description is not a map. A boundary is not adopted when it's only proposed, and the city itself called the assessment diagram the boundary map before having an advocacy afterthought. The court should affirm the decision below. Turning first to the language of HB 2440. The boundary map is the assessment diagram for reasons. First, the assessment diagram, which diagrams the property contained within a district, clearly qualifies as a map. Second, This diagram is the only map that is required under the relevant statutes. It wouldn't make sense for the retroactivity clause to be triggered by something that the statute does not require. Third, it also makes sense to call this map a boundary map. As Deputy City Manager Paul Blue explained it, App 146, the assessment diagram, quote, sets out the specific properties and boundaries to be applied for the assessment. So let's put this in context. There are 1,006 properties within the Roosevelt bid, and only 401 of these properties would be assessed. App 132. According to the dictionary, a boundary indicates or fixes the limit and extent of something. And because the assessment diagram indicates or fixes the limit and extent of the assessment, it is the very definition of a boundary. In other words, the city's map doesn't show who is going to be assessed. This is done in the assessment diagram. Finally, if you open up a dictionary, you won't find an entry for boundary map. In this context, it obviously has a specialized meaning, and the state's interpretation is consistent with how the term is actually used. The city does not dispute that before this lawsuit, it referred to the assessment diagram as the boundary map. It also doesn't dispute that it voted on approving the assessment diagram and, quote, setting the boundaries of the Roosevelt bid only after the district had been formed. Thus, the state's interpretation fits both the general and special meaning of the term boundary map. A resolution of intention is not a boundary map. Two things. A city is not required to adopt any type of map as part of the resolution of intention. It can refer to a map if it wants to, but it is not required to do so. So the city claims that a map actually means a textual description or a process. What my friends on the other side just said is the boundary setting requirement. So it's a process, but any map will tell you what a map is. A map is a diagrammatic representation of an area, and calling a map a process or a textual description contorts the English language. The city also has another problem. The retroactivity clause requires the boundary map to be adopted. To adopt means to accept formally and to put into effect. But a district boundary can't be accepted formally or put into effect merely through a resolution of intention. A resolution of intention, just as its name implies, an intention to do something in the future, only begins the process. It gives voters the chance to weigh in on a proposed improvement. Consistently, municipalities must give affected property owners notice, step 3, and an opportunity to object, step 4. These safeguards would be meaningless if the boundary of the district was set at step 2 at the resolution of intention stage. Instead, a district's boundary can only be adopted once the proposal in a resolution of intention is passed in step 5. Until this time, if you look at the statutes repeatedly refer to a proposed district during this period between 2 and 5, step 2 and 5, as being only a proposed district, and we've cited those references in our brief.
Council, I got a
Sure.
comment in my notes here that I think is a quote. Does this sound familiar to you? To this day, there is no diagram or boundary map for the Roosevelt BID.
Yes, Your Honor, absolutely.
So, in fact, it is the state's position today that what wasn't then remains not today,
Yes, Your Honor.
because what was originally filed did not meet the requirement,
Correct.
and nothing has been subsequently provided to change that.
Correct, Your Honor.
And is it because the city did not order the improvements?
There's two ways. If you view what their interpretation of map means, it wouldn't have been adopted until step 5 after the retroactivity clause. But the state's position is that the what is the boundary map is the assessment diagram, and they have never passed that. So they did create the Roosevelt bid in step 5 after the effective date of the retroactivity clause, but they have not yet passed the diagram, which actually identifies the properties to be assessed and allows voters. There's actually a weigh-in process that goes and vote required to adopt that boundary map. Another way of looking at this, so the retroactivity clause applies to retroactively to any districts for which the city or town council has not adopted a boundary map. Another way of looking at this, there is no district that exists at step 2 for them to have adopted a boundary map. It doesn't exist at step 2. The earliest that a district can exist is step 5. So consistently, the city points to no evidence that anyone from the city thought that it was adopting a boundary or establishing the Roosevelt bid in step 2. Indeed, the undisputed evidence is to the contrary. The city council was instructed that the resolution would only begin the process and was specifically informed, look at our statement of facts 2 through 5 in paragraph 10, that it could, quote, redraw the bid area. Similarly, in the minutes, the city continued to refer to the quote, proposed boundaries of the district. Index of Record 12, Exhibit 3 at page 49. And most glaringly, the city did not even vote on the boundary until after the adoption of the bid. So that's our textual argument. And if you get to any finding of ambiguity, you look at a few things. First, this is an undefined term. Second, you have the city council member, Mayor Stanton, in fact, agreed that HB 2440 would, quote, certainly affect the Roosevelt bid. At the very least, there's ambiguity, and if you get to ambiguity, there's no question the state wins. That is why they don't mention any of the other secondary sources that the courts rely upon to resolve ambiguity. You have the presumption that kicks in. Look at the Phoenix title case. Courts strictly construe municipal taxing authority, and every reasonable doubt as to the extent of that authority is resolved against the municipal taxing authority. They don't dispute this presumption's applicability here. Second, you have legislative history. Literally everything in the legislative history supports the state's position. I think perhaps the most significant piece from the legislative history was Senator Katie Hobbs' proposed amendment to remove the retroactivity clause. And she explained the reason for this proposed amendment. She said, this is, quote, the retroactivity clause would undo, unquote, the Roosevelt bid. And the Senate rejected that amendment. Every time the word map is used in the legislative record, it is used to refer to what the state refers to as the boundary map. So the legislative record speaks with one voice. You have the consequences of this law has generally been in place since 1913, as counsel points out. It could have absurd consequences by invalidating those districts. I believe our briefing on the special law and question and the attorney's fees issue is in our brief, unless the court has any questions on those topics, which I'm happy to address, or any other question.
You do agree that the content of the legislation can be imposed against, you call them bids? Is that what you refer to?
Business improvement district.
As it sits, it can be imposed today against districts that are attempting to be established.
Absolutely. It is elastic. Basically what they're saying is, my friends on the other side conceded that the general law is not a special law problem. Their only gripe is with the retroactivity clause. And look at the Arizona Supreme Court's decision in Gallardo. Gallardo said it is the law itself and not merely the classification that is the focus of the court's inquiry.
So, in the view of the state, the fact that at least the record implies strongly that this legislation was intended to exclusively target the Roosevelt Business Improvement District does not make it a impermissible special law.
There were problems with the Roosevelt. It does not. If the legislature wanted to fix the problems that went on with the Roosevelt Business Improvement District, it would not be impermissible that it perhaps affected the Roosevelt bid differently than other districts out there. There are 3 requirements for the special law analysis.
Was there anything in the legislative history that suggested that that this particular statute was intended to address hypothetical problems in the future as it related to potential BIDs?
I mean, the legislative history as a whole, I mean, really what this was about is the Roosevelt Business Improvement District revealed problems that were going on with the process. This was proposed, this resolution of intention was imposed right before Thanksgiving. The voters, the affected property owners had just a couple weeks over a Thanksgiving vacation to submit their protest. And this was an affirmative, you had to get a majority of the folks to affirmatively opt out of the bid. And the record, I think it's about a third of the notices that the city sent out came back undelivered. But these were effectively counted as yes votes. And so anyway, this bid revealed a bunch of problems with the process. It's effectively, I mean, it's nearly impossible to stop one of these bids under the old procedures. And this law flipped the burden of proof. A majority of the landowners don't have to opt out now. They have to opt in. So, yeah, the legislative history is replete.
You don't dispute, though, that the retroactivity clause applies only to the Roosevelt bid, right?
We have, the state has limited its investigation to the law and this proposed. We didn't investigate whether there were other proposed districts, but the state is not aware of any other proposed districts that it would affect, and there was none that I could see in the legislative record that would be affected by this bid. So as far as the state is aware, the retroactivity clause applied to the Roosevelt bid, but not to any other proposed district. And again, so what they're really asking is to add a new element to the analysis, to the special law analysis. You have inclusivity, rationality, inclusivity, and elasticity. And this is the fund manager decision. The fact that a statute's initial application concerned a finite number of known specific individuals and companies or companies will not render it a special law, so long as it may have potentially broader application in the future. The same is true here. HB 2440 applies not merely to the Roosevelt bid, but for all time after January 1, 2016.
But not the retroactivity piece.
Correct.
Will not apply to anybody else in the future.
Correct, but again, there in the fund manager decision, the court began by stating that it did not believe that the retroactivity clause could rationally be considered apart from the law. So just as the Gallardo case instructed, it is the law as a whole that is the focus of the court's inquiry, not any particular classification. And let's just say that you look at the court, the decision, look at this, the retroactivity clause in isolation. Part of the reason for the retroactivity clause, if you look at the state statement of facts at paragraph 22, was that the legislatures did not want the law to disrupt already functioning districts. Roosevelt was not like those districts. It was not functioning at the time. There had been no assessments. It had not been formed, or it was not operational. So even if the court could view the retroactivity clause in isolation, the legislature could rationally distinguish between districts that were operating and functioning from a district that was not. As the Doolittle case that the state cited in its brief makes clear, the city has no right to operate under the old rules. And again, this argument of viewing the retroactivity clause in isolation is contrary to the Gallardo case and the fund manager decision. Does the court have any other questions?
I don't think so, counsel.
Okay. HB 2440 applies to the Roosevelt bid. The court should affirm the judgment of the Superior Court and award the state its reasonable fees on appeal.
Roth.
Thank you very much. I want to address a few points, but if there are any questions, of course, I'd like to take those as the court would like. But a couple of things I want to address. Number one, the question was asked by Your Honor whether there was a challenge to the boundary map and the diagram as to whether it complied. The Roosevelt BID was established in November 2015 with Resolution 21370. The boundary map was adopted in that same resolution in November 2015, and there's been no challenge to the adequacy of the boundary map contained within the resolution. No suggestion that the city did not adequately designate the exterior boundary lines of the district. The challenge to the adequacy of the map is to the diagram that the state insists is the same thing as the boundary map, but otherwise there's no connection between the two. So if the boundary map in HB 2440 is the boundary map or the map showing the exterior boundary lines in HB 2440, then that was adopted without issue in the record whatsoever in November.
You're saying that if it was initially filed and just tracked through the history of the passage of everything that had to take place, then it ultimately just remains a part of the record and is, in fact, the boundary map. Is that right?
I don't think that's quite right. I think that it assumes that there's not an establishment of the boundary. The only time the legislature, the legislative body, I should say, is required to establish the boundaries of the district is with the resolution of intention, which was passed in November of 2015. That is the only legislative action that sets the boundaries of the district. Number two, there was an issue about adoption, about whether there was a final adoption. That is really the point. There is no other place where the boundary is adopted. It was passed and adopted. I want to address the fund manager point with my remaining time. The distinction there is that in fund manager, the retroactivity clause was used to sweep in pre-existing class members to be treated the same way as current and future class members. There it was certain kinds of transactions that would or would not be subject to the procurement code. Here, the Roosevelt Business Improvement District is the only district that will be destroyed. No other district will be destroyed by the application of the retroactivity clause. It does not merely subject the district to the requirements of the new law. It makes repeal certain. For those reasons, the city asks that the court reverse the judgment below.
Thank you, counsel.
Thank you.
We appreciate the arguments made here this morning, as well as the briefs that have been filed in this matter. We're going to take this under advisement. We'll issue a written decision in due course. And with that, we are adjourned.